should fully consider it. What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me maybe explain in some greater detail.
Sure.
I guess further to that point, Your Honor, to consider the attempted homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later. All of the defendant's motive that existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but there's some highlights there.
I agree with you. The financial motives that existed in March existed in February.
That's correct. But it's not only the financial motive, Your Honor. There is, and I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those
okay.
sufficiently in hand.
Your Honor, the second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman and their planning of the future. And specifically, you know, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for motive.
So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah. And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th. The state has shown probable cause that she wanted something stronger after February 14th and saw it again. Made a reference to the Michael Jackson stuff, which I think at least in the preliminary hearing stage I can take judicial notice, refers to a well-known event in which someone took a controlled substance and died. I'm tracking all of that.
Okay.
Where I stumble, or where I pause, is do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor. Let's...
Or attempted to do so.
Sure. Let's kind of focus in then on February 14th with the understanding that she, 2 days earlier, the probable cause understanding that she 2 days earlier purchased fentanyl from Ms. Lauber.
Got it.
Okay. So her conduct of that, her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes.
We don't know that it's a sandwich based upon admissible evidence.
Sure we do.
Tell me how.
The invoice from the Mirror Lake Diner entered into evidence is Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Were remind me, which exhibit is that? We're going to need to talk about that.
I'm
in
gonna
some
need
detail.
need some help on that.
I know what you refer to, but I just need to look at it with you.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that
Okay.
on the side.
But keep going. We can go chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms an order. The receipt corroborates, the invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner, and I think it's something like a 907 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
We then know at 9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the Camas area with an arrival time at some unknown destination approximately an hour from then. We also know, based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richins with her paramour, Eric Richins has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. We have that text exchange in evidence.
Okay.
Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with the reaction to fentanyl.
I've read it, but I can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction to fentanyl.
Yes, so that's the toxicologist, Matt Slauson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, in the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richins is sick enough that he's considering going to the hospital, and he's inactive for 2 hours. All of that consistent with fentanyl poisoning. And then, at that point, the defendant's own words are kind of important here because he texts her, right, of his illness, of considering going to the hospital. And what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home. She doesn't text. She doesn't call. She doesn't check on him. Their next communication is 2 hours later when Eric Richins checks in with the defendant. Notably, throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events consistent with a consciousness of guilt. She had texted on February 11th and 12th significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times with Mr. Kouri-Richins' testimony. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richins texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone, and also from Eric Richins' phone. That is in the moment consciousness of guilt. The next day,
Forgive me, I don't recall testimony from Mr. Kouri-Richins or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but...
Fair enough.
Okay. Okay.
The next day, after Valentine's Day, February the 15th, 2022, the defendant lamented to her paramour, if he could just go away, life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richins was dead. We've referenced Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Celebrite is 8. Can you give me that number?
Well, Your Honor, it would be found in the Celebrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot, it looks
Okay.
like a download.
Let's get there together. I need the exact language of that. It would be... Okay, got it. So this is, we got to be specific about this, a June 18, 2022 communication, correct?
yes, Your Honor, it's
Okay.
June 18, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this text is a discussion of the Valentine's Day 2022 incident as put forth publicly in civil filing.
I have some questions about this when you're done going through the evidence.
Okay.
I also have questions about the February 15 text messages, so just put 2 pins in those. I'm not questioning the existence. I didn't know those exist.
No, sure. So that glance was to get a copy of whatever the
Okay.
February 15th text was.
Well, it's if you would just go away, ... and then
Yeah.
I promise we'll be together on Friday or words to that effect.
Yeah, yes, Your Honor.
Okay.
We can discuss those kind of texts when we're both looking at them.
Okay.
The text to her false the text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages with Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen because she knows those facts are indeed true and indeed inculpatory. So do you want to discuss those texts, or should I continue on with kind of further answering your question, is how the homicide charge kind of relates directly to the attempted homicide charge?
Well, let's pause here for a second.
Yes, sir.
We also skipped over the, or didn't mention in that recitation, remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February the 25th.
It's here somewhere. I think it was 12 days later, right? Okay.
And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poisoning is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer the fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same. But she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49. And she learns that it takes a truckload of fentanyl to kill him. She learns that one bite in a sandwich isn't enough. It has to be stronger, it has to be administered at once, and it has to be a lot. And that's why Eric Richins' toxicology shows 5 times the lethal amount in his blood and 20,000 nanograms per milliliter were remaining in his gastric fluid. The attempt and the homicide are connected in MO and lessons learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Kouri Richins is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor, and I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that she ordered lunch from Mule Diner. We have him having a significant enough event that he contemplates going to the hospital. We have text messages on February 15 that draw reasonable inference that she wanted him dead. We have her out looking for something stronger when he did not die on February 14. We have a financial motive. We have the medical foundation. The difficulty is, right, and maybe this just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor or Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has some medical event around the same time. But here you'd say...
And the spouse dies 17 days later under very, very similar circumstances, same MO, connection between the two.
And is it 404 that lets me connect the dots here?
I don't even think the court has to go to 404. I think the court can connect. I mean, certainly it's probative. So, yeah, certainly it's relevant. I guess the court could connect the dots through probative, but there's no doubt, especially returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic violence defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
it's equally present. It's separated by merely 3 weeks.
Correct.
Yeah.
It's equally as strong. Now, Your Honor, the court raised, that this isn't speculative, and it's not. And Schmidt kind of talks to the notion, the point, right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just to make sure that the state's record, the most reasonable inferences, just to make sure, rather, that the state's inference is reasonable, and we leave the most reasonable inference question to the jury.
Okay. All right, so if you've got probable cause for count 2, you've got it for count 4.
Yes, sir, I think 2 goes out, or 4 goes out, 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, on all counts, but certainly counts 2 and 4. I have some questions regarding some of the financial counts.
Yes.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Well, for count 7, right, it's either it could be the forged signature, it could be the false representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there.
Yep.
Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature, I think, in either, bear with me, 9 or 10, or maybe 11. Candidly, I think 11 is the forged signature on the $100,000 policy.
Sure.
So
That relates to the claim, right? Count 7 is a false claim
right.
on an insurance policy. Count 8 is a scheme devised to get the money falsely from an insurance company.
But
Can or cannot involve a claim.
fair enough, but is it I acknowledge that we don't need to get into merger today, but
Sure.
is it the forged signature on the $100,000 true stage?
Sure, it's the signed application on January 28th and 29th. It starts with the application
Okay,
for the policy that issued on February 4th,
right.
10 days before the attempted homicide,
Okay.
a month before the homicide. It starts with that signed kind of application that the court will recall there was no way for the insurance company to contact Kouri Richins. Rather, they can only contact the defendant, right? The defendant used her business P.O. box. The defendant used her email. The defendant provided an improper phone number.
Okay,
And so submitting that application begins the scheme.
got it.
And the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is I'm going to submit a false application for insurance on Eric Richins' life. I'm going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richins' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. That's the policy of Exhibit 17.
What is 9 and 10?
9 is the fraudulent bank statement that the defendant provided to Iron Bridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. That's those are the cut and paste job
Got it.
statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? And then the forgery count in 10 is related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good. Ms. Lewis, how are you?
I'm fine, thank you. I'm going to address really just counts 1 and 3 and a little bit of 4. And then Ms. Nestor is going to address count 2
Okay,
and the remaining counts.
tell me where you see the gap on count 1.
All right, well, here's where I see the gap on count 1. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing. And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richins. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauber. What that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richins. She doesn't know what she gave Ms. Richins. Whatever she gave Ms. Richins has been through at least 3 people before it came to Ms. Richins. Ms. Lauber got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richins.
I don't disagree that we don't know, but knowing is not the legal standard that I'm required to apply today. So tell me why Ms. Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Let's look at the distribution counts and examine that.
Yeah, we can do it. All right, go ahead.
So looking at the distribution, and then I'll backtrack a little. So Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with, didn't say narcotics, but with controlled substances, is consistent with street fentanyl.
Blues, he said.
Okay, here you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud, so that's what was my pause there. But I have never seen a distribution case where we don't have anything that was distributed.
You mean a preliminary hearing or a trial? 2 very different universes.
Well, personally, neither. Okay? Personally, I have not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave her fentanyl,
Doesn't that form the reasonable belief, though? I mean, by all accounts, Carter Lauber knows the difference between a controlled substance and not.
well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some experience with it.
But Detective O'Driscoll testified that she said initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to, these concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis to
And I
find
understand.
that there was provision of a controlled substance.
I mean, I understand your position, where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he cannot say with any certainty
Sure.
what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl. What happened to them after February 25th? I mean, the third ones were allegedly received after
Right.
Mr. Richins' death, which is interesting, in terms of what these pills were actually for. And I think, and again, maybe a trial argument, it's interesting that if that was the purpose of these pills, that they were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills. And he does not know how, if those pills were given to Mr. Richins, and if they were, how they were given, who gave them, did he take them himself. There isn't any evidence as to that. And I understand, you know, the position and the very low standard we're looking at here. I get it. But that would be...
To be clear, the court's position is based on an application of the standard, not because I have an independent
I
belief
understand.
of what did or
And
didn't
I
happen.
didn't mean to imply that
Right.
it was your personal belief. I understand the standard.
Right.
And your application of the standard. Our position is still that there needs to be something more when you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's...
3 or 4.
Well, to both, but there's additional, of course, problems with the February 14th
Right.
distribution.
With if there is evidence sufficient to support a reasonable belief that Kouri Richins put some drugs in a drink and handed it to Eric Richins, there's probable cause for the count 3, right?
Yes,
Okay. All right.
you're right. But I think I've made my argument on that. And I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Carrington's testimony. I understand that. But nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly. Let me put it differently. If there was no motive, their inference would be harder to draw, correct?
Yeah, you're
Okay.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial ones.
Okay. I think I understand your position on 1 and 3.
Okay.
Thank you.
Thank you.
Good morning.
Good morning, Your Honor. May it please the court. If the court would indulge me just a couple minutes. I know you're so familiar with preliminary hearings. You do about 1 billion of them a year, probably. But I do just want to talk about what they are and what they mean to this system and to my client. So, Utah is a state that has decided not to employ the grand jury system to determine whether someone should be prosecuted for a felony crime. Utah has decided to place the entire power of whether someone's going to be dragged away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table. It's their power to fill out an information.
I have some role in the process.
Yes. I'm talking about before they get to you. I haven't got to that part yet.
All right.
You're jumping ahead of me.
Okay.
But what brings them to you is the people sitting right here. And it's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping. That instead of delegating that to a grand jury, people in our society that come together and close doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter. And it's gonna have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me in that.
I agree with everything you said about the law.
Okay.
What is the essential element of count 2 that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference regarding?
Causation, 100% causation. So, in order for them to establish an attempted murder,
Right.
they have to show that Ms. Richins took some act that caused someone to be in danger of death, right? She had to have caused something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So, I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And it's indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones, okay? So, in Exhibit 6, there are substances of text between Eric and Kouri that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Kouri's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and
an omelet.
And an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich, and I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. You eat it quick or you don't eat it. So she brings an egg sandwich home at 9:07. This actually hasn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe, and I don't think that the DA will, or the county attorney will dispute that.
Nothing in Camas is very far away.
Nothing in Camas is very far away. So it's about a 5-minute drive from the cafe to their home. So best case scenario of her credit cards being swiped at 9:07, she's getting home around 9:15 in that area. Maybe.
Is there any evidence that she actually went home?
Correct.
Well, I'm asking.
There is. On the phone. On her phone, the printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way to the house, and that's from her home.
Okay.
So she was at home. So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly. So it is perfectly possible, and just as inferential, that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Kouri and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm gonna go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right? So it is perfectly consistent with Kouri Richins' statement to her friend. They ate breakfast together. Which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food. So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by Eric.
Could you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So, I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me folks, I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day and Eric and I both were working from home that day and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't
Okay.
been exposed to any of the
Hey, folks, I need you to take a deep breath.
She-
Is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
All right.
But she admits she got it at Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no debate that she was not there at lunchtime. That didn't happen. So,
Right,
so that's clearly a mistake. So she leaves the house at 9:41 and is gone for the rest of the day. Eric drives to multiple other locations after she leaves.
Do we know, help me out, do we know that?
Or
Yes.
was he doing the estimating from home? This was unclear to me from the testimony.
So in the Celebrate exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's
Right.
making business calls ever since Kouri left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls. Then he texts Kouri at 11:27 and talks to her about some soccer fees that the boys owe. And then says a few minutes later, so between 11:27, he's talking about soccer, and 11:33, so he hasn't seen Kouri now in 2 hours. He says, I'm gonna go lay down. If I don't feel better, I may go to the hospital.
Right.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, he says, I wish you were here, and she's like, I would cuddle you. So that is very misleading to pull that statement out, and I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest. So in that period of time, he's been running errands, doing business calls, texting Kouri, very benign, normal day-to-day texts. Nothing about, I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic texts, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that. Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Kouri in his truck as they go back to the game because Kouri is running late. And that's the day. That's the day that they're now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever, if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Kouri that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th looking backwards? And I think that's a really important inquiry, because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, OxyContin. And as a matter of fact, he told, wait, I have to think if this is in.
Can I ask you some specific questions about
Yes.
this? So let's take it one piece at a time here in
Yes.
terms of events after February 14th.
Yes.
In your view, can the court consider Ms. Richins' text messages to Mr. Grossman on February 15th? Can I consider that at all?
Can you consider them? I mean, I think you can consider anything you want to consider in terms of.
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider under any set of circumstances, and it's often a difficult slalom course to ski. We did some of this yesterday morning,
Yes.
trying to get a sense from the defense of whether or not the court can consider things like the text message, quote, if he would just go away, end quote.
So
Or as evidence of an inference that she wanted him not around anymore.
But that could be divorce. That doesn't
I
have to be death.
understand, and we're not in a trial, and I'm not a jury, and so I have to contend with
But how
black
big-
letter law. Let me just get this out. I really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent, but I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting the urge to jump up and say, and that just shows she went home to give her the sandwich. That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards,
Right.
the text messages, her statement regarding ordering them lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive
Well, I
and
got
it's
that.
February 15th,
But that's not my question.
right? So how does the statement on the 15th relate to something that didn't happen? She's talking about it in the future, right? Like,
I guess the question is, if on February 15, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say he should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look at text that you wrote about your spouse, years later, and put it all into a cone of literal death threats when you say, I wish he'd leave, he's getting on my nerves, I want him to leave the house, I'm gonna leave him, I wanna divorce him. They put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple, they didn't have a perfect relationship. But to take a context, one single text, and to say that that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all.
Okay.
I don't think that is a connection.
So I hear you saying you can consider a judge, but it doesn't have any weight.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend?
That's what we just said, where she has not seen yet the time, like she hadn't had an
Got it.
opportunity to review the timing. So if she mixed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26th to Carmen Lauber saying I need something stronger?
Again, that's after the 14th.
It's a backward-looking statement, though, or at least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she had just recently got something from her. So,
Right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
Or more specifically, not necessarily referring to what she got on the 11th,
Right.
but could be from the 25th.
but I mean, you have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, I mean, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
Well, this is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404B, is to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions and the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Right. Well,
In your view, does 404B work backwards or does it only work prospectively?
it only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognized that that's very, very dangerous to base a prosecution on somebody, well, somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system, and that's the whole basis for their argument on the attempt. That's the entire basis, because they know they don't have proof. They don't have medical proof. They don't have. We heard testimony about allergies. We heard about all of that. So I mean, there's innocent explanations for everything that happened on the 14th. Every single thing. So that doesn't lead to a reasonable belief. They are 100% relying on an action and conformity argument.
I don't think we heard the admissible testimony of allergies, but I take your point.
I'm sorry. I'm trying really hard
That's okay.
to separate it in my brain.
I understand.
I actually think it's included in the, I believe it's included in some of the exhibits, but we'll just leave it alone just in case I'm wrong about that. I can check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable cause.
I agree.
They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th.
I think the only thing she got wrong was breakfast or lunch.
Well, I think her location about her being home all day is one of the things they lean on. We were working from home that day.
I mean, that's easily provable. So it's not like when she's talking to her friend, she's trying to remember the day back, a few months later. And she got part of it right. I mean, and part of it wrong. And I just don't know if it's just, how do we know that, what purpose would that be? How would that serve as a lie?
Well, the argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie. Because you're with your boyfriend. And you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay. That's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present when
She admitted she was present with him, and she was. She brought him breakfast.
Okay.
So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. It's a statement against interest,
Okay.
in my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments. I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction over these acts. They did not establish where they occurred.
Why isn't there a reasonable inference that Kouri Richins was making these applications and forming these schemes from Summit County?
And they have to show that. You can't just out of whole cloth make that up. There's no evidence that occurred.
Well, the standard of proof is the same for every element of the crime, right?
But
So
there's
evidence
no
supporting-
evidence that was submitted.
She lives here, her business was based here. I think there's a basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record.
Okay.
I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the, I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong, I'm seeing several merger issues in this
Yes.
information, but merger is a fact issue that's handled after conviction, am I right about that? Not at a preliminary hearing?
Not after conviction, before, you said after conviction, you meant after.
Is it before
charge.
submitting it to the jury or after?
Merger?
Yeah,
I always do it as a pretrial motion, but
okay.
I may be wrong, maybe two, you're wrong.
I don't think it gets considered though at a preliminary hearing as a matter of law.
Well, I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them, absolutely, I think you can do that.
Do you
But,
have a citation for that? I thought it was the opposite at a preliminary hearing.
well, I think you would just argue that they can't make two separate counts, so there's not sufficient reason to believe that a second crime was committed because it's all one. So that's your finding, that it's a reason, you can't reasonably believe the second crime was committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So,
I'll take a look at this.
yeah. And then I think on the rest we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day. It wouldn't.
1 and 3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the ag murder and intent, right?
No, those would be two separate crimes.
Tell me why. You can't
Because
commit them without doing the distribution, right?
Right. I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay,
So
so
they wouldn't
then
merge.
why isn't, on the one hand, forging a signature and on the other hand, making a false statement when trying to collect on the claim? Why aren't those two separate crimes? What is the merger
Because
you're
they're
arguing for?
the two insurance fraud charges, because that is the same offense. Insurance fraud is not two separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the two insurance fraud charges. I think
Okay.
they merged.
All right,
And
and just to be clear, you think they merge because it is the same fruit of the criminal conduct? That is, there was only one policy.
right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Thank you. Can I just have 1 minute before I sit?
Of course.
Just one more thing, Your Honors. And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richins could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
Okay, I understand your position. Thank you. Mr. Blood.
Your Honor, real quick on just the merger issue, it's two different policies. Count 7 relates to the $250,000 two-stage policy.
Does?
Count 8, I think, relates to the $100,000 policy.
That is not the way it is charged. I think that is, you're going to need to amend the information if you want to do that. And frankly, I don't think there's any allegation of fraud, or there's any, tell me why there's any reasonable belief regarding fraud related to $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richins.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's two separate diaries. This is why I'm asking.
Your Honor, I think
They were paid out at different times.
sure, in the one diary, though, they discussed both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They
Well,
are
let me
separate
ask you this.
diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering, and so I can show it to you, but I don't know that it's
I understood you to be saying count 7 is based upon statements made during the process of collecting the proceeds in June. Count 8 is the scheme to get the policy with intent to kill Eric Richins to collect it.
So, this one is the COLA 2022 policy. This is the COLA 2017 policy, which there's 250, 100. There's the scheme. 250, 250. Yes.
Are you referring to the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that,
Oh, that came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
So this is 1803. Hold on a second. Let's get to the bottom of this. My apologies, I had it backwards. Okay, so, count 7, thank you for this clarification, is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion, the purpose of admitting the evidence is further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. The most of the defense's argument against bind over the attempted homicide count, as the court kind of noted, a lot of that goes to the jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Richins eats his eggs, or whether he goes shopping beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today. Part of that countervailing evidence, I find it ironic that the counsel argued we hadn't heard one piece of evidence from Richins. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove an MO. I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
We've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all the reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly, but I don't even think it's necessary for the court to get to a probable cause determination. And, Schmidt, in discussing probable cause, references that probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information.
Or a search warrant.
Or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's an argument. Overruled. I understand the state's point. Okay. It is 11:29. We're gonna come back at 11:50. Oh, Ms. Nestor, my apologies.
Very quickly, I checked the ME report. It did reference the fact he was positive for COVID, but
Okay.
it did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you. 11:50. Court's in recess. Thank you.